Fall Risks as We Age and the Basics of Premises Liability by Colleen Mriglot. Falls in older adults are a leading cause of injury and death. As we age, our bodies become more rigid and muscles and joints stiffen, eyesight can diminish, and cognitive changes may lead to a decline in physical ability. Changes in vision can cause us to inaccurately judge distance and therefore have less spatial perception to understand our environment. Data shows that the risk of falls increases due to a variety of factors, including physical conditions and health status, which are intrinsic, meaning based on personal causes within the individual's body. Other factors are extrinsic, environmental influences, or those acting upon the person, such as hazards from loose rugs, poor lighting, or bad footwear. It is estimated that each year, approximately 30% of those aged 65 years and older will experience a fall, while 50% of people aged 85 and older will suffer a fall. Of these, 20%, 30% will have moderate to severe injuries that will interfere with their ability to continue living in the community without assistance. They will need hospitalization or have an increased risk of death. With age-related physiological changes, our gait patterns can change, making us less coordinated and vulnerable to correcting balance issues or overcoming challenging walking surfaces. Clearly, the risk of falls as we age is an increasing threat. How can this risk be reduced in our aging population? The way in which we move about in the world can improve our ability to avoid injury and maintain living independently longer. Experts have identified various interventions to limit falls, among them exercise programs, environmental modifications, supplements, medications or withdrawal of medication, and stabilization devices. A recent peer-reviewed article explained that a combination of vitamin D and calcium supplements will reduce the risk of injury from falls by 40%. This is a notable finding. A person at risk for falls should undergo assessments for gait stability and/or other physiological issues, such as the need for cataract surgery to improve vision. A physical therapist is qualified to make a gait assessment or perform a functional capacity evaluation, while other medical providers or specialists can make appropriate recommendations depending on the specific conditions. While at-risk individuals or their family members can take measures to reduce or improve the risks of falls, there are circumstances when no amount of intervention is possible due to someone else's negligence. In these cases, where a dangerous condition on a property exists, the injured victim may be able to bring a claim for personal injuries resulting from a fall. These types of premises liability claims arise based on the duty owed to the visitor on the land. Generally, a person's status or purpose on land will determine the level of liability a possessor has for any injuries. The three classes of visitors under Washington law are invitee, licensee or social guest, or a trespasser. An invitee can either be a visitor for business benefit or a public use, which entails the highest duty owed, that of reasonable care to ensure that the property is safe. This includes a duty to check for and discover any dangerous conditions, which covers known or obvious hazards if the possessor should anticipate such harm to the visitor. There are exceptions in which a possessor will not be liable to an invitee, but they are more limited and will not be covered here. The next class of visitor is a social guest or licensee, which means the person has permission or the tolerance of the possessor to be there, and it is not solely for the possessor's benefit. Generally, a possessor only owes a licensee the same level of care they take for themselves and their family. Thus, the possessor owes the duty of care for known dangerous conditions when they know the guest will not discover or realize the risk posed. Lastly, a trespasser is someone who enters land without permission or invitation. No duty is owed to a trespasser except not to cause willful or wanton injury. Willful means intent to cause such harm, while wanton means an intentional and reckless indifference to protect a trespasser from known dangers. Common causes of property injuries arise from tripping on broken and raised sidewalks, unpainted parking curbs, unstable stairs and ladders, and slippery surfaces. An elevation change of a half an inch or more is a discrepancy that is well known to cause tripping hazards. Construction sites open to the public can also be a cause of injury. For example, an older woman who is a former client tripped after a contractor forgot to remove a string that was raised 3 inches off the ground, which was used to line up a new sidewalk. The string was nearly invisible, and as she passed it, her foot caught and she was flung face forward onto a gravel road. She suffered a broken nose, fracture to her knee, and cuts to her face. Older adults who are already at risk for falls must take extra care to protect themselves, both as their bodies change and when dangerous conditions are present. The best interventions appear to be strengthening exercise programs and environmental modifications in our homes.